The panelists for the session, Mr. Anind Thomas, the moderator for the session, partner at AZB and Partners, Ms. Deepika Kinhal, CEO at Cord, Mr. Paul Thottan, product manager at Sama, Mr. Subbaiah K G, head of products at CADRE, and Mr. Vasu Aggarwal at Lucio.
So, our topic, as you see on screen, is AI and ODR is the future here. I'm Anand. I'm going to do the easy job of asking questions. I'm taking this as an opportunity to ask them everything that I, as a practitioner, want to know about ODI, how AI is being used as part of the ODI process, and what we're going to see next. Again, before we start off into the specific aspects, I'm going to request each of my panelists to help me introduce the topic in terms of what is ODR and then what do we see as AI in ODR. Me personally, when I look at ODR, there is of course ODR, there are ODR service providers, there are other platforms that are traditionally looked at as being ODR as opposed to other forms of dispute resolution. But for me, arbitrations that are conducted online are, and it doesn't have to be by one of the ODR service providers or ODR platforms, but an arbitration that's conducted entirely online can be ODR. Courts are increasingly encouraging litigants and counsel to argue matters online. Very busy senior counsel from from Delhi appear before our High Court online. They get the opportunity to appear in multiple courts on the same day. You can have mediation that's conducted online, conciliation that's conducted online, arbitrations like we already discussed conducted online. So at least that's what I see as the universe of ODR for me as a practitioner. But Deepika? I think they're all on.
Hi, good afternoon, everyone. Thanks, Anand. I think I will just take off from where you left and highlight one of the points you made with respect to how there is no one single definition of what ODR means and includes. ODR can be anything which is facilitated through the integration of technology at any stage in the life cycle of dispute resolution. And at the other end of the spectrum is where end-to-end all stages of the life cycle of a case are managed only through technology. And that is the spectrum which also correlates to what in technology terms we say deterministic to probabilistic journey between automation and AI. So just to take a step back, what we at CORD do, which is Center for Online Resolution of Disputes, and as the name indicates, it is an online dispute resolution offering platform plus services, which facilitates dispute resolution through negotiation, mediation, conciliation, and arbitration. At present, what we do is essentially provide an aggregate of all the technology tools that all of us may be using across various aspects of our life, as well as our aspects as dispute resolution professionals. Right? This can be your virtual hearing facilities, to scheduling facilities, to using some level of documentation management online, and some level of automation as well in terms of using templates, in terms of using some predictable analysis for certain categories of disputes. All of that put together on a single platform. That is what online dispute resolution platforms today offer. Along with that, we also have our technology arm, which is Terrace, which is what most of you here may be familiar with, which ensures that artificial intelligence is experimented with and deployed for live cases in an agile manner. While CORD looks at end-to-end dispute resolution, Terrace looks at how can we develop modular solutions which can be used for dispute resolution within CORD or elsewhere. This is sort of the world of ODR that we are bringing to our clients today. There are variations of this that India is currently experimenting with through multiple private ODR service providers, and we will hear, I'm sure, more of that from other speakers. But the bottom line is there is no one single definition, and we are still definitely on an explorative journey today.
Great. Paul, anything to add?
Hey, is it audible? It's fine, yeah. I think I just wanted to sort of frame it also from, I think some of us also product folks here, and you hear a lot about the legal side of legal tech, but I don't think enough is spoken about the tech side of legal tech as well. So I thought I'd just take a chance to frame ODR also from maybe like a design and product lens, right? So if you look at any product, any service that you use, in the design world, the framing for how can you build product love, like how do you love a service that you're using, is always a large part of it comes from the error handling. Okay, so if I'm using a service and it does exactly as it's supposed to do, I'm using an app, it does everything as it's supposed to do, that's the normal course of things. But if something goes wrong, I hit some roadblock, I'm trying to do something that I want to do on this app, but it's not letting me do that, something else is happening. Then there's two ways that apps would handle this, right? Like a well-designed app will try and empower the user to realize their mistake and then correct that mistake for them. All this long-winded way to say that I think even dispute resolution is essentially the same for the contract world. It's the error handling for the contract world. What happens when something goes wrong in your contract? That's when the dispute resolution clause comes into the picture, right? So the way I think of ODR is to leverage technology to empower people to resolve these errors on their own. So ODR really is a lot about that. That's the way we look at it. Sama also is empowering people to leverage technology to resolve disputes on their own. So whether today that is within the framework of conciliation and arbitration. So we empower people to file their cases easily and then give them access to a subject matter expert who can then give them a decision. Whether that is today or tomorrow, it could be like an AI-assisted autonomous mediator, right? So that's also, I just want everyone to think of ODR broader than just alternative dispute resolution, but it's also really about leveraging technology to empower people to resolve disputes on their own. I just thought I'd ground ODR also in that lens.
Thanks, Paul. Subbaiah, anything to add? I think we've had two very, very different perspectives that we've heard from the first two speakers.
Yeah. So hi, good afternoon. I'm Subbaiah. I'm from CADRE. I think everybody put it right that the universe of ODR is quite huge. Now, obviously, from a CADRE perspective, we call ourselves a tech intermediary. So what do? We basically we provide a platform where we don't mind what the sector is, who are the disputing parties, who are the parties that will actually eventually do the adjudication. We are a platform that will help you, get these disputes resolved faster at a lower cost and be more efficient at doing it. So it's about bringing down time, and also, like Paul put it, the end user needs to be considered. It should be user first, which means that the disputing parties need to be able to use it and actually feel that it is a better system than what it is there today. And whatever is required as additional tools for them to be able to do that for each of the individual parties. I think that's what we kind of work on to get automation, AI, all of it into it to help that happen. So if you look at it from a broader spectrum, we are basically a tech intermediary which is sector agnostic, and we don't mind getting into different sectors. If any one of you are really interested in trying it out, please reach out to us as well.
Vasu, before I ask you to add, I'll also start off with asking you the next question, which is, once I have your thoughts on what using ODR is, how exactly is AI being used in ODR? What do we mean by AI in ODR? And then we'll bring it back this way.
Sure. Thanks, Anind. Am I audible?
Yeah.
Okay. Hi, good afternoon, everyone. I'm Vasu. I'm the founder of Lucio. I'm a lawyer by education. I graduated in 23. And back in 22, with my roommate then, I started Lucio. And I'll come to the two questions that Anind has asked, but maybe let me start by sort of identifying what is it that lawyers do, right? Back in 22, I was speaking to a partner at a law firm, and he told me something very interesting. He said, 60% of what we do isn't really the practice of law. It's perhaps only the 40% of it that's practice of law. curious, right? What does it mean that 60% of it isn't really practice of law? And I was curious. I asked him, okay, why are you saying that? That's when he started describing that, look, when I'm doing something like a due diligence, I get a data room. The first thing I do is download all documents, sort them, rename them, arrange them in a certain order. And all of this even before I start applying my legal brain. I'm spending so much time extracting clauses from documents and putting them in my DD report than actually applying brain on seeing what the risk is, right? I could be spending so much time sort of summarizing a marked up document to find out what the key issues are, even before sort of applying my legal brain or commercial brain on what's really going on in this. And that's when I started wondering that, okay, there is a possibility that a lot of times there are these tasks that are done which don't sort of push you to apply your legal brain. I was speaking to a senior who's working at a law firm, and she told me that she'd started to hate her job purely because she was spending more time putting title documents in a chronological order, extracting dates from that, extracting who is passing a title to whom, and at what point in time, summarizing these documents, so on. Another one of my friends told me that they had to spend 2 weeks sorting correspondences in a construction arbitration in different issues. That might be change of scope or utility shifting or so on. What are these tasks, right? These are really the tasks where you don't even need to apply mind, let alone say your legal education or your legal training. These also take a lot of cognitive load on lawyers, and sort of this is what we try and automate at Lucio. We pick problems of this sort and try and help you solve those. But now coming back to questions that Anind posed, right? He asked a very good question on, okay, what is it that's technology? And what is AI, right? And today, we see a lot of this mismatch on what is automation versus what is AI versus what was before AI. Perhaps I'd say that there are 3 different ways of looking at it, right? Perhaps 3 generations. First being automation, where there are deterministic aspects that you're putting together to get a certain outcome. You know the input, you know the output, you'll get it that way. This is automation. We started seeing perhaps the first wave of predictive analysis in the legal space through some clause tagging and named entity recognition softwares, right? These allowed you to get or extract sort of clauses from your contracts. They could also tell you perhaps out of the 100 contracts that you have, jurisdictions for certain contracts are India, certain maybe Singapore, so on and so forth. This is perhaps the second wave. Perhaps pre-transformers is what I would say. Pre-transformers AI is where you used to do things like this. But more recently with ChatGPT and OpenAI coming up, we have a completely new wave of AI where you can use these very strong language models to solve a lot of your lawyer problems. This is how I would view the difference between, say, the starting point from automation to AI. Anand, should we just right now go into what the use cases of AI are?
I think it makes sense. It's a good segue into where we are seeing AI being used. One, in India, of course, the state of how it's being used in India. And for me as a practitioner, I'd also like to know how it's being used across the world, because we know that these practices percolate from one jurisdiction to another. And so we can expect practices that are working elsewhere to work here. So if I could actually start again with that question, Deepika.
Sure. I think I'll start out with taking a few examples that are relevant for the audience here. When Vasu talks about automation, right, he mentioned the word deterministic. This is where you're not really looking to analyze and have a plethora of options to choose from. It is as simple as 2 + 2 = 4. Of course, with calculator, it is a click of a button exercise, but you don't really need artificial intelligence, so to say, to help you with this. And here, some of the things that can play a role in making the lives of anyone involved in dispute resolution easier are things like chronologically arranging your documents, right? what this requires is that you have structured data to begin with. So here is where what matters is how we are ensuring our documents are maintained. And this can be applied across small law firms to big law firms. It can be applied in courts. It can be applied from the perspective of lawyers to judges, to even clients, companies, the way they maintain their documents. Right? So this is a technology that already exists. This is tech intervention of the simplest kind. On the other end is where you're looking at assistance with perhaps say judgment writing. And here, while India is not yet there, we are seeing that certain other jurisdictions are already experimenting with some form of predictive analysis to aid judges. From what we understand, the most advanced form of application of this use case is being seen in China. But even here, of course, everyone is cautious because you do not want to, at this stage, override human intervention when it comes to ultimate decision making. So what is AI being used for is to give the judges the assistance until the very end point where, say, A to D options are given to choose from. And then the judge applies their judicial mind to say that, okay, this is my ultimate decision. But in this journey, the time that is invested by the judge is reduced by 1/10, right? And that is the kind of use cases that we need to start moving towards here in India, both as far as ADR is concerned and the court workload is concerned. And I come from the background of corporate law, then litigation, and then policy space. And in my most recent past role, I was working with the judiciary. I have served on e-committees of the Supreme Court. I've worked with Niti Aayog in mainstreaming online dispute resolution. And in that, our effort had been to look at these multiple use cases across various jurisdictions and take the essence of it to India and not really replicate everything that is happening over there. Some of the hurdles that are unique to India is something that we always keep in mind when we design our solutions, be it what the judiciary is looking to adopt or what we at CORD seek to do. It is sector agnostic, it is client agnostic, but at the end of the day, we are looking at who the ultimate beneficiary is going to be. We have requirements with respect to language diversity. We have hurdles due to lack of digital literacy, access to digital tools across the country. So keeping all of these in mind, we will have to see how the AI journey in India will truly translate into action.
Paul, have you seen technology, AI technology being used in other fields that we think can be adapted and used for dispute resolution in India?
Yeah, so I think there's a common misconception. I feel you feel that artificial intelligence is going to be some sort of stone cold, non-empathetic sort of chatbot, which may not be able to handle the nuances that is required in mediation. Because mediation is supposed to be inherently very reliant on emotional understanding, high on EQ, all of that. So you traditionally think that these chatbots may not do solely that. You need a human touch. You need someone who can understand tone of voice, body language, a lot of those things. But you'll be actually really surprised by how good some of these chatbots are at even doing tasks like therapy, counseling, all of that. So there's an app called Dot. It's built by an ex-Apple designer, and it's sort of like a personalized assistant. But it's extremely good at having these really sort of empathetic conversations from you. And I would argue that it's going to be way faster at understanding what is your position on a particular issue much faster than probably that comes from a human. And another example, also sort of taking from there is there's I think there's something called Hume, right? Hume builds sort of these voice APIs, and what they have done is they've built this model that really tries to understand what are the emotions that are coming in through someone's voice, right? So they have something called an expression management API, which is trained on a lot of different conversations to understand what are the different emotions that a person is expressing at any time while they are conversing. And where this is helpful, how it's being used currently in the West, is there's a sports team, and the sports team now has like a very large fan base, right? Now the fan base is sending in a lot of videos, these reaction videos of all the highlight reels and things like that. And so they want to compile some videos. So what they would do now is just show me the top happiest or the ones which are most excited, right? And then from like 10,000 videos, you'll be able to come down to the top 10, 15, 20 videos which have the most expressive, most energetic, most happy. And so I think the way I would see it is, in India, if you're using a lot of mediation through voice, right, a lot of it is voice-based. Can you assist the mediator in understanding, okay, these are the sort of emotions that are coming in through the person at the other end, and then use that to assist in mediation. So those, I think, some of the examples I can think as corollaries which are from other industries, but is the use of AI, which could really benefit even in dispute resolution.
Interesting. So, Subbaiah,
Yeah.
getting down to some more concrete example of how you use AI tools at CADRE in the life of a dispute, whether it's case management to enabling practitioners who are actually helping resolve those disputes. Where all do you see the use of AI currently, and what do you think we should be looking at in the next few months?
Yeah, I would probably set this up in 3 phases. So from an AI perspective, or from a tool perspective, or from a platform perspective, I don't think individually AI can stand by itself. Right? What that means is that the AI needs to be plugged into the system, into the platform. The automation needs to be part of the system. Everything needs to be part of a jigsaw puzzle, which eventually fits in place. Right? So at CADRE today, if I were to break that down horizontally, I would say it would be to drive efficiency, then it would be to provide assistance, and then third, I think for everybody, which is a moonshot, is to try and get the judgment itself going. From that perspective, I think from an efficiency, we are quite there already. So we help with everything that is required to do with document management and evidence management and all of that. From an assistance perspective, as I told you, we are mixing all 3 of them. We are trying to get a editor out in place, which is a mix of, take something from the case that is already there on the platform, put it there. Take something that the AI, generative AI, gives to you from the inferences or from the fact that it essentially drives from the case documents as well as the case proceedings, and put it in place. All right. So we have all of these coming from templates, from facts, and also from inferences, and we are ensuring that we are able to give this to the dispute resolution professional, who can then look at it and sign it off. So that we are currently in that second phase, which I spoke about, which is the assistance phase. Soon we'll also be trying to drive inferences to a larger extent, in the sense that get to the point exactly. But you need to understand that AI is a black box, and to get that black box going, you need vast amounts of data, right? In a particular sector, because we talk about different sectors, any particular sector, for us to actually get it right, you look at these generic models that are there today. Obviously, there are fine-tuning techniques and RAG techniques and all of that are there on top of these. But to get things actually right, you need quite large amount of data. And I think from an Indian perspective, I am not sure that any platform or anything has that amount of data for us to train and get to that immediately. I see that in a few years' time getting there, but that's where we are in our journey as CADRE on using AI and stuff inside our platform.
Excellent. Before I come to you, Vasu, because you do a completely different thing from what CADRE and CORD do, I'm going to ask Deepika how exactly you're using AI as part of your offering. You said it is part of the offerings that you have on a standalone basis or within the platform that you operate. But if you could give us some concrete examples that I, as a practitioner, can understand that this is how AI is being used, and this is where I believe this AI is going to be able to help us.
Sure. The advantage that Team CORD has is that we work in tandem with the technology arm that I mentioned, which is Terrace. With Terrace, we are able to, one of the key flagship offerings that you all may be aware of is legal transcription. And this is based on ASR engines, right? And this,
What's an ASR engine?
it is a speech recognition engine, which ensures that across languages, wherever large language models have been developed, it is able to convert speech to text. And the most recent offering that we have is translation along with transcription. We recently tested this in a Singapore tech law conference where we had a panel of English and French speakers. Along with speaker diarization, we were able to demonstrate live the French speech being converted into English and corrected live. So at the end of the event, you had 100% accurate transcript available for everyone to peruse, and that was also being displayed online the way it is currently being displayed. Everything that we are currently speaking is being transcribed, but imagine the complexity that arises when speakers are speaking in multiple languages. So that is the progress that we have been able to make at Terrace. Building off of this offering is what we are able to do with other AI tools, which includes summarization, which includes querying the documents that you generate through transcripts. And this is already happening, right? One of the key things that Terrace does is transcribe arbitration hearings, especially international arbitration hearings, and we are also the service provider to the Supreme Court of India. In fact, the Chief Justice of India recently acknowledged that he is able to undertake better research and analysis thanks to the transcripts that are available, which documents all the arguments that are advanced in courts. So it is not just tech as an end in itself, the way we are currently putting it to use, but it has actually ensured that it contributes to the betterment of jurisprudence, and it also makes the lives of lawyers and judges easier because it reduces the cost and time involved. For instance, earlier, because the hearings used to happen across multiple days, you sometimes lose sight of or have accurate record of exactly what has been argued. But now, thanks to transcript, at the click of a button, you will know exactly what arguments were made, and using thematic summarization tools, which are embedded along with transcription services, you can search the text based on specific arguments that were advanced, which is given to you in a summary format. So these are the use cases that are already available and that we are already offering to our clients.
I think in a country like India where there's just where we're so multilingual, may not be for large high-profile arbitrations where your documents are in English, all your proceedings are in English. But I think in a lot of other cases, the fact that these transcripts can be translated on the go to different languages makes it more accessible, both ways. For example, there are courts in Bangalore where you have to cross-examine Kannada. Yes. I can't, but there are. And then I have to get somebody to read the transcript back out to me, or not even the transcript, but read what has been recorded physically by the stenographer after the judge had dictated the answer. I have to get them to read it back to me for me to understand it and then prepare for the next round of cross-examination. So something like this, I think, will make my life a lot more easy. Similarly, the fact that in India, transcription is not the default situation. Our arbitrations, our ad hoc arbitrations do not have transcription. Cross-examinations go on for days and weeks because we still conduct it the way it was conducted in court, which is that a question is asked, an answer is given, then the judge dictates the answer out. So it's not being recorded real time. The steno is not taking the answer that I may give as a witness, but taking the judge's summation of that. So it is not true to state that, and the question is stated after that, which makes one, takes much longer. Two, it doesn't give you the essence of what was actually said there. And that is lost when you're trying to do a final argument, because you have this judge who's already inserted himself in the process, or the arbitrator who's already inserted himself in the process and dictated what he's understood of the answer, as opposed to letting the answer itself be recorded. So I think those two things, well, at least to me, are things that I immediately see can help my practice, can help
Absolutely.
us get more efficient.
Absolutely. But just one quick point there, Anand. In fact, combining that with what one of the other speakers was mentioning, which is identifying the emotions behind the text, emotions behind the speech, that is already being put to use in a lot of these customer-facing services. Looking at user experience, the ratings, all of that is now assimilated, which can be brought into the legal world. So even when you're reading a transcript, it is possible for you to, through certain icons, identify what was the emotion of the person who was speaking those words. So the use cases can be several. So I think we are just at the beginning of that journey.
So when Paul mentioned it, one of the things I was thinking of is not in conciliation, but again in my own narrow field. I'd like to know how the judge is receiving my argument, whether he's really, or the arbitrator is receiving my argument, whether I'm getting through to him, or this is a point that let me not waste too much time on. Let me move on to something that he's either he's receiving better, or I have to sharpen my argument as we're arguing. So those are use cases again that are there. Sorry, Subbaiah, you had something.
So just a thought that we usually keep discussing at CADRE, right? So is hearing mandatory? Is emotions really required? Can we make it asynchronous? Like, is all of this actually required? Like, I'm not getting into the details of regulatory details of what cases what can happen in a cross-examination and all of that. But one thing that we are piloting and we want to do is try to keep everything asynchronous. So that kind of helps you not worry about this. Is also another angle to look at it. I'm not saying that you can have everything without meetings, etc. All of that, but I think there are scenarios where you could try and see if that can happen. So you don't leave it to the bias of emotions, if I may call it, right, to actually be part of it.
No, I'd look at emotions as being a feature, not a bug. But again,
so that is a lawyer speaking.
Again, never saying never, never say never, and you never know whether you'll end up with a situation like that. Today, I don't think we're there, but we do see document-only arbitrations, for example, where we're not having cross-examination, especially with larger corporate disputes where everything is correspondence. In a lot of matters, we don't end up with cross-examination. We go straight with the documents into final arguments. That's where we sometimes end up. Who knows? We might not even, at some stage in life, we may not even have those. I don't know what I'm going to be doing then. But there might be a situation like that. But that's it, Vasu, from the developer, from the side of somebody developing these kind of things that platforms can use. What have you been doing for the ODR or the dispute resolution space? What have you been doing?
So perhaps, perhaps I'll mention what use cases we are seeing, regardless of whether we provide them or not. What is it that market is actually getting out of AI today, especially sort of dispute resolution lawyers, right? But perhaps it's useful to differentiate the use cases for different stakeholders. Stakeholders from judges and institutions and court side of things, and the stakeholders who are practitioners, right? Lawyers who are arguing these matters. From the perspective of institutions and judges, perhaps one of the easy use cases, as Deepika mentioned, is transcription, right? It's already being used in the Supreme Court of India. It's already being used in a lot of arbitrations. This is something that's actually making lives easier. But to consider a completely different example from the perspective of a Supreme Court registry could be, how do we identify defects in pleadings using AI, right? Which takes them a lot more time. This is something that Supreme Court is in fact working towards. Another different example could be where at the time of appeals, certain cases can be batched for those appeals, depending on the kind of issues that they contain. And these are also the kind of things that take a lot more time for registries, the judges, the High Court overall to go through. I was also discussing this with one of the institutions, and they said, look, we have thousands of these arbitrators' profiles, and we want to know who's the most relevant arbitrator for perhaps this dispute basis this issue. AI can today help find which is perhaps the most relevant arbitrator for that issue or for that dispute basis their profile. So think about it as you have a large volume of data and you're able to extract insights from that large volume of data. I'm also seeing that apart from these sort of use cases for centers and sort of registries, there is also a growing sort of acceptance within judges as well. For instance, IIT Bombay and NLS today are working with Meta to come up with a tool that's going to assist consumer judges or consumer courts in making their decisions. When they say making their decisions, all they're looking for is, hey, can I get all the data into various different buckets for me to be able to analyze violations more easily? Can I just check very quickly whether something's within limitation period? Can I be very quick in seeing whether I have the jurisdiction at all to solve something like this? But from a completely different stakeholders perspective, which is you and perhaps the other practitioners here, there are various different use cases we're seeing of AI today. One very simple use case is summarization of lengthy documents. This is something that what we've seen is accepted now quite widely. Other use cases like preparing chronologies, right? You mentioned that in a documents-only arbitration, you deal with thousands of correspondences, emails. How do you make sense of a data dump that has been given by client to you, right? What you need is really a quick way for you to be able to skim through the events, the storyline, what's really happened. And today, AI is able to help with tasks such as this. Another interesting use case we've seen very recently is fact-finding, right? You have thousands of these documents, and you want to know, is there any document in which perhaps X has been represented as an agent of the company? And what do you need to do now? You need to go back to each and every document that you think is plausible to have anything related to that, and then look for it. But is it possible for AI, which is able to consume a large quantity of data at once, to answer this question for you, right? We're seeing these kind of use cases come up. For instance, more recently, there was a construction arbitration in which somebody had a very simple question. Is there a place where the other party has admitted to delay themselves? And perhaps this is not even direct admittance, but they were able to find documents in which there was a sense of admission of delay. And that this is the kind of fact-finding that can be done a lot faster using AI. There are other few use cases, for instance, the ability to sort documents, the ability to create knowledge repositories, right? You have lots of precedents, you want to see if you worked on something before. For you to be able to see, okay, I'm giving a uniform sort of sound advice. I've given that before and I'm giving it in future, right? Another useful use case we've seen is folks trying to create cross-examination questions from entire case files. Because AI is able to understand perhaps that what that party may have done throughout the dispute, basis different documents, including contracts, including correspondences. AI is able to create or curate a first list of questions that you might want to ask a probable cross-examinee, right? These are some of the use cases that we are seeing on practitioner side of things.
And again, this is to all of you. Where do you see India in terms of adoption of technology and AI versus, at least in the ODR space, versus the rest of the world? Are there things that are being done elsewhere which are not yet being done in India? We heard the China example of at least helping with the decision-making process, which I don't think we're doing here. But from what I hear, with that's something that you're at least doing, at least planning to do in a limited manner for the consumer, for consumer disputes. Is there anything else where you think India has not yet adopted it as we should be? I understand, at least when we look at it right now, you guys are at the ODR, the ODR service providers, the ODR practitioners seem to be using technology a lot more than any of the I won't call them mainstream dispute practitioners, but practitioners who are not in the online tech space. So is there something that you think that we should be using more often that is an overlooked tool which could be in our arsenal, or are we pretty much there, at least when it comes to ODR and technology? All of you. So whoever, Deepika first, if you have anything to say.
sorry, just have been grappling with this problem for far too long. So have a few things upon my mind. Um, I think I wouldn't jump the gun in terms of saying that AI is the way to go to resolve a lot of issues that we face as dispute resolution professionals or even as legal professionals or as court system which is overburdened with crores of cases. I think what is more important for us to currently look at is how we can embed the existing technology to improve the time and cost efficiency to whatever extent possible. AI is the buzzword. It is something that is fascinating. I understand, and there is always this urgency to bring in something that is out there. But I think we can start with something that is already out there that has worked in other domains and adopt that for certain cookie cutter cases, as we call it. Say, for instance, wherever there are disputes, where parameters are fixed, right? You know that beyond these 10 metrics, this case is unlikely to have anything more. It is almost like a formula. Those are the cases where I think we can bring in structured data, we can bring in algorithms to improve the efficiency with which you're able to arrive at the conclusion. Say, for instance, what is already being experimented with Section 138 cases. The highest percentage of case load today that the judiciary faces is because of Section 138 cases. Is there a way that we can ensure that by the time the case reaches the judge for application of judicial mind, they have everything on their table to apply their mind only for 5 to 10 minutes to arrive at a decision, and even that decision is templatized so that it can serve future analysis of similar cases. Tenancy disputes. Again here, it takes years on end to resolve tenancy disputes, even though the kind of arguments that can be advanced, the underlying documents that can be presented are hardly any. So these are the use cases that I think we should start focusing on and try and resolve for them one case category at a time. And that is a similar approach that we are adopting even at CORD. The main sector that we are focusing on is BFSI. But here we are able to do that because of the data that is already available, because of the manner in which documents are already maintained by insurance companies, by the banking sector, by certain businesses. So if best practices are inculcated at the very inception of a case, with respect to the judiciary, it may be e-filing. With respect to businesses, it is the way they have their onboarding documents templatized. I think dispute resolution process will automatically become significantly faster.
Yeah, so just taking off from what you had to say, because that strikes a chord with me. Disputes, like you mentioned, the check bounce disputes under 138, the courts are so overburdened with them that the policymakers are actually thinking of decriminalizing it, which I don't think is the right approach. But those are disputes that it's documents only, literally. You have a check, you have to see whether the check bounced, for what reason it bounced, and then look at whether the various criteria that are set out is literally check the box. But those disputes, because of how overburdened our system is, and because the person who's drawn the check clearly doesn't want a decision as soon as possible, take years and years, which for something that, if these boxes are actually ticked, you would end up with that being resolved in a few, like you said, a few minutes. It's not rocket science. It's one of the easiest disputes to resolve, but our system is, so overburdened by it that it doesn't move. And as a result, like the tenancy disputes again, people file because they know that it's going to give them time. A tenant will file a dispute if he knew that he's going to be evicted in 3 months because there is no merit to it, or he's given, on humanitarian grounds, that tenant is going to be given 6 months for him to go and find an alternate accommodation, because that's what finally happens here. He will not file that because he knows that there's no point spending time, money, and effort to get 3 months more. They file it, and the reason why there are so many that are pending is because he knows that that's going to buy him an easy 3 years. By the time the court actually gets the time to hear your matter, take evidence, decide the matter, it's 3 years, 4 years, then you go and appeal and you tell, and in appeal, our High Court now has been telling people that either I hear your appeal and dismiss it because we know there's nothing there, or you tell me you want 6 months, I'll give you the 6 months and dismiss your appeal, but you get 6 months today. And you'd be surprised the number of matters that get over because the High Court has told him, I don't see merit in your appeal. I'll give you 6 months today, or you want to argue it and face the consequence of being evicted tomorrow. And a lot of matters get settled that way. So if we're able to use technology and reduce the pendency, I think we'll have a system that with less load works more efficiently. And that will also mean that a lot of matters that we believe are without merit but only there to game the system and get time will go away. That said, I think that's a good segue into how exactly, and we heard, sorry.
Yeah, I'd like to add to
Yeah.
what you said, right? You mentioned, is India at a stage? That was the
Yeah.
question that you started with, right? I think when you look at whether we are there, I think you need to look at the ecosystem as a whole, right? Now, fintech, where are we in the world? We are in one of the top, right?
Yeah.
So anything that's related to data is all digitized, right? So everything is available. So I think from my point of view is that India is actually primed now to get all of this in place because everything is available for someone to initiate a dispute to actually also evaluate it, right? So it's, I think, a balance that regulators need to get together and figure out where and when they need to actually deploy these so that, whatever backlog and whatever timelines that you're talking about can be concised significantly.
Excellent. So that brings me to a question that wasn't on the list, so sorry for throwing it out at you. But again, so any one of you can tell us. But what have you seen as the experience from the SEBI dispute resolution that's been moved to the ODR space? What are your views of how well or how badly it's working? Anybody?
Yeah, I mean, I can speak about it. So we are associated with both BSE and NSE for SEBI disputes. I think the best part is when you see the investor actually writing back to us, saying that how ODR or CADRE ODR in this particular case has been able to not fall into the pressures of the defendant parties who are huge huge conglomerates, if I may call it, right, have huge legal power at them, and still, investors are protected. So we get these consumer emails which says, thanks for doing this. This has helped us. That's essentially placing it where we are, right? So we are getting technology and helping people resolve disputes, not just like the common man get the benefit out of it, and we are seeing that. So we see that there is merit in what we are doing there. It's, as I told you, it's about adopting that, in the other scenarios.
Great.
If I may add.
Sorry, Paul.
Yeah. So I just want to put in one shameless plug here, which is that so Sama was the one who had the chance to actually build the platform as well, the Smart ODR platform on which these disputes are getting handled. So I think we had a sort of bird's eye view on some of the ways that some of the learnings that we got from that experience also. And I think the biggest takeaway was sort of the ODR framework that SEBI has created is not only for referring disputes, but also sort of getting the enforcement also that comes out from the mechanism. They really define timelines very tightly. There's a lot of follow-up on compliance as well. So because of that, once the dispute enters the foray of the ODR framework that's been defined by SEBI, it goes through a very well-defined timeline of 21 days at a pre-conciliation stage, which is free for both parties, and is overseen by one of the stock exchanges or the depositories. And then it goes into if it gets referred to ODR, then it gets sent into an ODR institution that is allied to one of the exchanges or depositories. And then again, they have 21 days strictly for trying to resolve that dispute. And then from there, if it needs to go to arbitration, either party can initiate arbitration and goes in for 30 days. So it's a very tight sort of timeline within which the entire framework operates. And because of that, I think there's, at least I think enforcement-wise, there's been a lot more, we're seeing a lot more teeth, and because you're getting support from the regulator who's established this framework, I think that's a very new sort of thing that we've seen. So,
Sorry, Deepika.
Yeah, I would just like to add a couple of points to directly answer your question as to whether it's going well. It's been a year of SEBI-driven online dispute resolution mechanism for securities market. And in this 1 year, there are around 7,000 odd disputes that have been resolved through ODR, accounting for roughly around 200 crores worth of dispute value. I think the numbers speak for themselves. Beyond just these numbers, I think we have to also look at how this has been enabled. And I think that is where the true value of this system lies. And it has, in fact, paved the way, I believe, for other regulators to follow suit. What SEBI has done is issued this master circular where some of the more relevant day-to-day processes have already been chalked out, which has ensured that all the online dispute resolution platforms that are today offering their services to SEBI have some say in how the disputes are resolved and are also equally held accountable for ensuring transparent and secure way of resolving these disputes. Paul mentioned the timelines, which are followed extremely strictly. The average dispute resolution time is around 30 days, right? And this is across conciliation and arbitration processes. The way the cases are allocated to ODR platforms is through a round-robin method. There are around 6 ODR platforms that are currently offering their services to these disputes. CORD currently works with NSE and NCDX in resolving the disputes. And what we have seen is because there are, say, 3 to 4 specific categories of issues that may arise, we are able to train the dispute resolution professionals, the neutrals, that are the conciliators and the arbitrators, to specialize in these disputes. We are able to create that human resource layer, which is extremely critical. Our case managers across all dispute resolution platforms, who are again trained to speak to the investors, speak to the trading members, and understand with a complete understanding of what the underlying dispute is. Even though the case manager's role is limited to facilitating the scheduling of cases, bringing the parties together, because they have a thorough understanding of what the disputes themselves are, the quality of service that they are able to give to the parties is significantly enhanced. So because the regulator is involved and has created this policy framework, I think the entire dispute resolution ecosystem, as far as the securities market is concerned, has significantly improved. And ultimately, it is the experience of the end user that matters. And that, I think, has improved. And I'm hoping that this will set the trend for, say, other such regulators to adopt something similar, be it MSME, be it consumer courts, which see a lot of volume and are overburdened already. This is the way forward, I believe.
And before we adopted ODR at the SEBI for stock exchange disputes, how long was it taking? Do you have any idea of how long it was taking before ODR was adopted to now in the last 1 year? Is it significantly shortened
I
the timeline?
unfortunately do not have a comparative figure. Does anyone here have the number?
But I'm assuming it's shortened it
it
significantly.
has shortened it.
Significantly.
And the other, I think, also is the increasing accessibility for investors in rural areas also significantly is raised because it's now moved online.
Yeah.
Whereas earlier, I think they had a IGRC, sort of investor grievance redressal mechanism, where you had to participate. Either it was a lot more physical conciliation, physical arbitration, one that, or the other was you had to go to an investor service center to sort of participate. So it's sort of become easier now to participate in the process also, and it has definitely significantly reduced the time.
Yeah, so
And
accessibility not just in terms of being able to go online, but like you're saying, time and cost,
Yeah.
which time and money cost.
And
both.
also language diversity, if I may
That's-
add.
yeah.
Right? We have had cases across 24 states in the last 1 year that CORD as a platform has handled. So we have had to bring in our case managers from those specific regions who are familiar with the language to be able to assist the parties to log online. and we have spent time in educating the parties to be able to have their Zoom account and attend the hearing effectively. So these are additional value adds that you get because you have service providers like us embedded. If it was a centralized mechanism that the regulator itself runs, I'm not sure if this level of detailing would have been possible.
Got it. You just mentioned the fact that we should be seeing other regulators hopefully picking this up. Are there any of them, if you can tell us, if it's fine for you guys to tell us, if are other regulators also looking at similar mechanisms? Is there interest, or are everyone still waiting, saying that it's only been a year, we'll wait a little longer before we try to experiment with ODR?
It's above my pay grade. No, I know that of one public information at least is the fact that I think there was a CP Grams tender that was floated out last year for the consumer grievances. I don't think it completed the entire course. I know that we were part of the process, but I'm sure that the government is actually looking at these mechanisms to actually resolve disputes that are huge in number, that have backlogs that are for years together, that need to be looked at.
Yeah, I think our courts as well have been somewhat keen to push stuff online, leverage technology, and that'll bring me to my next question. But so much so that in judgments they've said, the Supreme Court has said, requested the High Court to look at various areas or various different various types of matters that can be handled online. And hopefully being handled online is not just saying that you have online hearings, but also leverage technology, AI, whatever it is, but use whatever type of technology to hopefully, get the process moving as fast and as efficiently as what seems to be happening at the securities disputes stage. But when we're talking about regulators and regulatory issues, have any of you faced any statutory or regulatory hurdles in terms of wanting to use ODR or wanting to have alternate dispute resolution mechanisms being used for some types of disputes and not being able to do it because of a statutory or a regulatory limitation? For example, you were talking about the BFSI space, and it immediately brings to mind the fact that banking disputes, a lot of them can't be taken anywhere else but the debt recovery tribunal, which some of us who actually practice there know how long it takes for matters there. So are there any places where we believe that if the regulations change, those kind of disputes will benefit from the ability to use one alternate dispute resolution mechanism that's not the DRT, but ODR or any other alternate dispute mechanism?
Maybe I'll start. I think things have significantly improved over the last couple of years. For instance, with the Mediation Act that was promulgated, ODR has specific recognition, right? There is a chapter on ODR. And this makes things significantly easier for a sector which is still at its nascent stage, and we still are looking at how to secure buy-in from our end clients. Therefore, statutory recognition makes a huge difference for the ecosystem at large. Having said that, there are definitely certain legal hurdles that we will have to overcome to take complete advantage of technology. To just give you a few examples, going back to the SEBI example that we were talking about, one of the requirements over there is stamping of arbitration awards, right? And we all understand how complicated the stamping regulations are across states, the diversity, the costing requirements, and the lack of access to e-stamps across all states. What ends up happening is that because of this particular step, the costs increases, and you're not able to provide the end-to-end digital dispute resolution experience that you could have otherwise provided. This is where I'm hoping that the policy and the laws align with what is possible through technology already. There have, of course, been judgments which have put a spanner in the works. The one you mentioned with Vidya case, where we were not able to take on a chunk of disputes because of the embargo placed on banking sector disputes. This again, I think, is something that the judiciary needs to be mindful of when passing such a blanket bans on how certain disputes can be resolved. Carving out a jurisdiction for these specialized tribunals is well and good, but taking away an avenue for alternative dispute resolution mechanisms, I think, is doing disservice to the ultimate litigants who need that efficient way of dispute resolution. So I think we have some distance to go, but there are certain specific examples where the law needs to change and certain others where the judicial precedent needs to be overcome.
It's actually the lawyer in me who's thinking and not the entrepreneur, which is, aren't the cases where you're restricted from doing arbitration going to be the same where you're going to be restricted to do sort of follow the ODR platforms and methods of
Absolutely.
ODR?
The ODR is a subset of ADR. So if they're
Yeah.
not allowing you to arbitrate, then
Yes.
you can't do any of it. You have to go to that to the specialized tribunal, the DRT in this instance. So, but I think that's been interesting. Now, for me and my fellow practitioners in the room, I know we've touched upon it in various disparate portions. But as a practitioner, a legal practitioner, somewhat technological Luddite, how can I use ADR in my practice? What are the easy ways, the low-hanging fruit, so to speak, for me to use ADR today to become a more efficient lawyer, if nothing else? From anywhere between the agreements being drafted to the entire dispute resolution mechanism. What are the various tools that are available to a practitioner to help him get better at his job, which is to help resolve disputes? I'd actually start with Vasu and then come this way.
You mean from AI perspective?
From an AI perspective. Like I said, but again, it's not just AI is a subset of technology. I know the topic is AI, but I don't want to make a clear distinction saying that only AI.
Yeah.
But if there is technology that we aren't using today but is available and should be used, I'd like to hear.
So look, there's a lot of technology that's coming up that can help you do a whole lot of things, right? I mentioned a few use cases a few minutes ago,
Yeah.
things that we support and I know a few others support. Very, very simple things like summarization, fact-finding, sorting documents, preparing chronologies. In fact, an ability for you to be able to ask questions across large data rooms, right? These are the kind of use cases every lawyer, and not just a dispute resolution lawyer, should be using to make it far more efficient for you to be able to actually do your job, right? You owe this to not just your clients in terms of getting things more efficiently for them, but also to your juniors, your folks who are spending a lot of time doing things that are mundane in day-to-day life. What actually is actually a precursor to this question is a question of adoption, right? And what are the fears that one might have with AI? And I think that's what has really been the big hindrance in a lot of lawyers adopting it today. We can do a very quick, short experiment in the room to see what are these sort of hindrances, if you think that will be interesting.
Absolutely. Have questions, please go ahead.
Maybe we can just ask like a couple of questions in the audience today. So how many of you, perhaps we can see a raise of hands, think that use of AI would make juniors lazy? Lazy. You think that they won't learn as much as they are learning when they're doing something from scratch today?
Can I just make a comment? I didn't ask
Yeah.
for voting. It's a very difficult question to say that it will be lazy, but if I see a change when I started my practice, one of the reasons we were supposed to do the research was actually to go and pick up an SEC journal, pick up an AIR, do some research, and we didn't end up just learning what we were looking for, but there's a lot more law that we learned around reading it. Of course, come to the time now as well, be it non-availability of time or whatever. Now you just go to Manupatra, to Alexis, just pick up that point, get some judgments, and they're on it. Now, has that made me lazy or has it made me more efficient is a very difficult question. But yes, that was also a very useful way, especially for me when I started off my career. Today, it may not be that I was not able to spend that much of time. So that's probably the comment that I have on this.
That probably was actually one of the questions that I had to ask a lot of the model, thank you, around, we're going to come onto it in one of the later sessions, is around developing efficiencies and how we utilise that. And that's a massive bonus, nobody wants to do endless chronologies and all of that. I can understand that. But what makes me slightly nervous is when you're talking about use of AI for interpreting emotion and telling somebody what that is effectively. Because isn't part of process or part of one's learning and analysing key skills in terms of retaining and developing that human specialism so you can apply it as you go up the line. If somebody is then telling you that this paragraph equals this person is angry, what impact does that then have in terms of the learning or the developing of that specialist technician, no pun intended, from a legal point of view?
Yeah. So, exactly, right? These are some of the aspects that we think about at the time of adoption of AI. Let me ask slightly different question, just taking the experiment forward, but thank you so much for your comments. Which is, would you be comfortable if somebody assured you AI is going to be effective 98% of the times? Just a show of hands, yes or no. 98% of the times. Okay, do you think that your juniors or when you are working, you are accurate 98% of the times? Just a show of hands. Yes, I think I'll be accurate 98% of the times. I think that makes the point slightly clearer, right? Which is the big hesitation in adopting AI today is it even accurate, right? On the other hand, the question that we should also be asking is, are we accurate as humans, or are we as accurate as humans? Perhaps I'll take one more example, which is perhaps slightly more controversial, which is how many of you today are unhappy with the hourly billing systems that lawyers adopt?
It's all practitioners in the room.
It seems all of you are quite happy with the hourly billing systems that we adopt in the legal industry. And AI is seen, and I don't see any hand up, surprisingly, which is we're all very happy with the status quo on how hourly billing is done. AI, on the other hand, sits completely opposite to it, right? To say that I'm going to help you reduce the number of hours that you bill, meaning that I'm going to earn less. Should I even look at AI then? Should I even be adopting it? So, I mean, the point that I was actually trying to make was very simple on adoption of AI, right? What are the challenges today and perhaps the narratives today that don't allow us to reach a wider audience when it comes to practitioners?
Yeah, no, and now that he preempted my final question, we can move on to interaction and questions and comments from everyone in the room. Absolutely.
I get the 98% accuracy bit, and I wouldn't argue with that. When I was a child, if you wanted to go somewhere, sometimes you used an A to Z, and you worked out how to go. I was definitely less accurate than following Waze or Google Maps, so I take that, and definitely that's the benefit. I think the question was more in getting improved and increased accuracy from something that's, from technological advances. It's the de-skilling in other areas of that individual, and how do we balance that? I think that's what I was trying to say. I don't dispute the accuracy element.
Yes.
It's just how we manage the development of other skills then, because there are those skills which are going to be taken away by the fact that they've been superseded.
That's, in fact, actually a wonderful point, right? And this also comes from what Neeti was saying a few minutes ago, which is there was a point in time when we were actually looking at case libraries. We were going to libraries, trying to read the entire volumes to understand, hey, okay, this is the case that might be relevant to my case today. Today, we just key in a few keywords and get the right cases and just rely on them. We're not even sure at this point that the keywords that we've inputted are even correct or not. And yet, somehow it's now become a skill that if I am doing a research, I know of certain keywords that I can rely on and get certain judgments out that are going to be much better than somebody else. Exactly similarly on this line, and this is something we realized, is the fact that you can go to the library and find a precedent that has been de-skilled to a significant effect. The new skill that has come into place is my ability to cognitively think about what are perhaps the right keywords that I need to key in to find a judgment. Similarly, from that wave to this wave, it's going to make a big difference on how users are able to use AI, who understands the kind of prompting that might be necessary to get a particular result out of an AI. How do I make use of a tool to get to 80% of my task and then do the 20% of it manually? There is a level of upskilling required. In fact, I generally say this, which is education and training has been two key missing aspects in adoption of AI. There hasn't been enough education, there hasn't been enough training, there has just been more and more hype, which has in fact today led to a situation where the adoption of AI is quite slow. But yes, I 100% agree that we're going to be doing a lot of de-skilling and upskilling at the same time on different aspects of skills.
I think the context also really matters. Like even to your earlier point about you saying that it's kind of scary seeing AI being used in these highly emotionally charged sort of mediation, etc. I think the context really, really matters. And all of this artificial intelligence being used does not negate the need for actual intelligence. You still need that AI as well. And I think even when earlier Subbaiah was talking about how AI is a black box, right? I think you feel like how can we sort of let it be that some AI is analyzing some text and coming at that this is what the emotion is coming out of that. And I think there's also a little bit of retraining our own mind to sort of understand how technology has evolved. So is it just predicting the next word, or is it also doing some level of reasoning, right? Which is higher order reasoning to be able to come to like make a logical representation of that text and then understand what that text means and then come and say that, okay, this probably means this person is angry. And I think if you use these tools more, I think that's the only way that you would be able to identify whether these things actually work or not, is to use them more. And there are, I think, a lot of practitioner tools that people could be using here to understand how they really can help everyone in their daily lives. I know one, for example, is there's this tool called Jurisphere, which I know a lot of my friends have been using for legal research. So it's quite good. It's a RAG based tool. So RAG is essentially retrieval augmented generation. And that's really good at sort of reducing the amount of hallucinations that can happen when you do a particular search, right? That's one of the biggest problems with AI, like Vasu was saying, was the reliability aspect. But I think there's a lot of work going on in AI to ensure that there are more guardrails to get more accurate responses, reduce the number of hallucinations. And the more and more, I think the systems are also getting a lot more reliable. And there's a great example which one of the OpenAI founders actually gives on whether they are just next word predictors or do they also do some kind of reasoning. And the example he gives is think of a detective novel, right? It's a very complicated detective novel, a lot of layers, a lot of characters, a lot of situations, all of these things are happening, okay? And then at the end, the last sentence is, and the murderer is. The better a large language model or an AI tool is at predicting what that word is going to be, you have to, and it's not easy, right, for it to just predict a word, because there are a lot of words that it could predict. But it's then, if you're able to get more accurate responses there, then you know that it's not just predicting words, it's also probably building some sort of a logical basis for why it's predicting that word. So I would say use those tools more, see how those tools are, whether they're accurate, whether they sort of model your own behavior and fit with your mental models of how these things would be done by a human. And then maybe don't dismiss it yet, is all I would say.
Yeah, a more philosophical answer would be, do you still use Google Maps to get back? Even though you know the route you've learned, because you're looking at traffic now, you're looking at all of the other things, right? So the more you adapt, the other skills you'll complement with the more time that you have. So that's how, I mean, philosophically, that's how technology also has evolved, right? From a typewriter to a computer to anything, right? So the more you adopt, you get more time to develop other skills. And if you're not going to use that skill that you've learned to get to place A to B without the maps, then, I mean, you're not going to use it down the line. So I think adoption is key. How far and how well we adopt, I think that's where things get going.
And taking from there, I think your question is very valid, right? It's a concern, it's a fear that all of us share. How is the technology going to disrupt? and it actually reminded me of what used to be my father's claim to fame a few years ago. He could remember 100 phone numbers, right? At any given time, a minimum of 100 phone numbers by heart. Ask any child today or ask me today, I hardly remember any phone numbers. And similarly, right, what was being said about Google Maps. Recently, I was chatting up with an auto guy, and he's in his late 50s. And he was talking about how he knows every gully in Bangalore, and that used to be his USP. Like whenever the client came to him, whenever the customer came to him, he knew exactly how to go, and if he wanted to charge more, he also knew what other routes to take. But come today, you have your people with Google Maps who hardly know one lane from the other, right? They are as clueless as the customer themselves are. So yes, generation after generation, I think with infusion of newer levels of technology, it may feel like our notions of what is important in terms of knowledge, in terms of intelligence may be changing. But I think contextualizing it for our world, say with the caseload that the judiciary is facing today, if we are able to significantly reduce the time taken for cases that the technology can help with, that will mean that the judicial mind is freed up to apply for more complicated disputes, more high-value disputes, or disputes that actually affect the life and liberty of people at large. And similarly for lawyers, if we are able to actually automate a lot of tasks, then that means you have your time to offer more creative solutions to your clients. So I think that is where technology is in a position to empower rather than disrupt. And directly answering your question on what it is that lawyers can do, I think my ardent request to all the lawyers in the room would be to include ODR clauses in your contracts. Please advise your clients to include ODR clauses, not just ADR clauses. I think that's the way forward. Thank you.
Done. Thank you. And on that subject, we're out of time. My fellow panelists, thank you so much. I've enjoyed not just this panel, but the fact that I've spoken to you over the past couple of days as well. It's been eye-opening for me. Hopefully the audience has got at least some of what benefits that I got. Thank you all, and they're around in case anyone has any more questions, but we are out of time for this panel. Thank you.
Thanks,
Thank
Anand.
you.
Thank you, everyone.
Thank you.
Thank you for taking out the time.
Thank you for that insightful discussion.